In the matter of marriage of Brenda Boucher and Richard Boucher, I have announcement of appearances, please.
May it please the court, Your Honor, the petitioner appears via Zoom as with counsel Tony Ruiz.
May it please the court, the respondent, Richard Boucher, appears via Zoom with counsel Brady Teen.
It looks like we're on today for the respondent's motion for hair follicle testing. We had this scheduled previously, and then I believe petitioner had changed counsel. So, Mr. Teen, it's your motion. I guess before we get going, counsel, how do you wish to proceed? Are we going to have testimony, or is it just going to be argument?
I think we just proffer, and I'll let Mr. Ruiz. We had exchanged some emails last week about today's hearing. I know Mr. Ruiz had a couple points maybe he wanted to bring up to the court. I don't know if he's, and I don't want to speak for you, Tony, but I don't know if he is necessarily opposed to it. I know he brought up some concern about, the time frame that hair follicle tests go back. And so I guess maybe that's the first question is if they're opposed to it. My understanding from discussions with Teresa Greenwood, the Chief Court Services Officer, whose office conducts the hair follicle testing, the hair follicle tests go back approximately 90 days. The main reason being the length of hair that they use. They use, I believe it's approximately an inch or so of hair, and that the length is what determines the time frame that it goes back. And so I guess maybe that's my first question, is if Mr. Ruiz and his client is opposed to submitting the testing. I think we stated the reason why we're wanting the testing in our motion, that being when the home study was conducted back in March, a bottle of urine was found in the petitioner's fridge. I think I mentioned in our last hearing, but obviously there's really no other reason to have a bottle of urine in your fridge unless it's to circumvent urine testing. We're hopeful this matter was going to be resolved previously. I guess that's kind of an explanation for our delay in requesting the testing. I believe our motion was in May, about a month and a half ago. But obviously this matter hasn't been resolved, and I think it's appropriate given the petitioner's, she's currently on bond, I believe, for a possession of meth case. And due to that bottle being found, also my client has some concerns about some people that I don't know if she's still associating with them, but had been associating with some other people earlier this spring that I guess raised some concern to my client as well. But we think it's appropriate to order the hair follicle testing that goes back further and wouldn't be able to be circumvented at least not as easily circumvented.
Mr. Ruiz, your position?
Your Honor, my client's not opposed to testing. It's the nature of the testing to accurately reflect what the court wants to determine in the best interest of the children. I talked to Ms. Greenwood too. She was unaware what the margin of error was on this 90 days. Quite frankly, in my long career, I've never seen anything in the criminal law, drug testing, anything that is certain in terms of reflecting. And if the court wants to determine the status of my client in terms of making sure, which we all do, that she's not using illegal substances during parenting or otherwise, then the UAs would be the best reflection of that, even if that's every 2-3 days. The court, I'm speaking to the knowledgeable when I'm talking to the court about UAs versus hair follicle. The question becomes, what if that hair follicle that give or take 90 days goes hot, yet she's had negative UAs throughout this tested on bond? The question becomes, how far does that go back, and does it reflect a period where my client admits that she had some issues? Even though she moved back last year, there were issues that she had that brought her to this date. Furthermore, this idea about urine in the refrigerator, you'll notice that that court services didn't take any steps, accepted her explanation with regard to it. My client understands why the court wants testing in these instances. The question is which testing? And that UA would most readily reflect it. If you look at the history through court services, she's been negative with regard to it in attempting to move forward. That's where she has an issue with the requested testing.
Okay. Thank you. Any further argument from either party?
Just briefly, Your Honor. I used to work for community corrections. I would say I'm fairly familiar with urine testing. That was the primary testing that we used. The issue with urine testing, it is accurate. It can be quite accurate, but it's also, initial screening. But urine testing for a substance such as methamphetamine, which is the main substance of concern, it's only detectable in one's urine for approximately 3 to 5 days. I would say 5 days at the later end of it. So it only tests if there was immediate use. It doesn't test, if I'm not sure how often Ms. Boucher has been reporting to bond, but from other clients I've had on bond, they don't report, but maybe every other week or so. Like I said, perhaps it's more often. Perhaps she's tested more often. But again, the concern is that there was a bottle of urine found in the fridge. My thought on the margin of error and if it would, if there is a positive test, and it's possible that there is a positive test, I don't think that's something that should prevent the test being conducted. I think that could possibly be an issue if the test is positive, but I don't think that should mean we shouldn't or that's sufficient justification to not conduct the hair follicle test. That can be brought up if there is a positive test later.
Mr. Ruiz, anything further?
No, Your Honor.
Okay. Well, council know the court's pretty up to date on substance abuse testing, working with the recovery court. And the hair follicle testing, it does give you a glimpse back 90-day period as to if there's any use during that 90-day period, but you can't tell how many uses or when it was used. And the court's aware that Ms. Boucher is under supervision with court services, and they do the random UAs when they meet with her or whenever they're requested. And that's why I asked Officer Hecker last time if the UAs of Ms. Boucher are observed, and she said they were, and that there wasn't any issues during those UAs. Because there's only really two reasons why you would have urine in your refrigerator: if that you're trying to circumvent a UA or you're trying to help somebody else circumvent a UA. And so if Miss Boucher is being observed in her UAs and she's not trying to circumvent her UAs, then it only leaves one other option. So the court's going to deny the motion for hair follicle testing. I just don't think it would benefit the best interest of the children here. I don't think it's going to further help the parties determine what's in the best interest of their children. They've already went to mediation. They've reached an impasse in mediation. And so I believe this matter probably just needs to be set for a final hearing where testimony can be presented and regarding a final determination of custody and parenting time. So at this time, like I said, the court's going to deny the motion for hair follicle testing. I don't think it's not going to be beneficial in this situation. Last hearing we had, Miss Boucher was in treatment, so she's currently in treatment, or if she's finished treatment. So there's really no other treatment component, even if the testing was positive. So I don't see the benefit of the hair follicle testing. So we're going to move forward. Court's going to deny the motion. And are the parties, I guess, moving on? Are the parties ready to set a final hearing, or there's need to be further discovery? I guess, counsel, where are we at on that issue?
In Your Honor, we're actually currently set, and I would share the same position of the court that we just need to set this for a final hearing. Petitioner's prior counsel had filed an additional motion to modify the temporary orders, and it's currently set for Wednesday. I filed a response, I think, at the end of last week or some point last week. It kind of stayed in the same position that we just litigated that issue, and it's the same issues that are going to be for the final hearing. That we had in at our prior hearing, and then what Wednesday's hearing would be. So I don't know if there's any purpose of keeping that. I don't know Mr. Ruiz's opinion. I was going to ask him last week, but forgot to. If we want to keep that hearing, or if we just need to set a final hearing for this. We had a previous discovery deadline. I think that was in May. Obviously, that was with Petitioner's prior counsel. I had at least corresponded with Mr. Coombs about. I didn't have any real detailed discovery to conduct. It was just essentially income information for child support purposes, and we had agreed to exchange that past the deadline. But I'm open to Mr. Ruiz's opinion in terms of our hearing that's set for Wednesday.
Mr. Ruiz?
It doesn't seem like it's very good use of the court's time to set it for Wednesday when we're going to have final hearing here relatively soon. I'm a little bit unsure, Your Honor. I apologize for not being prepared of where on discovery, but I anticipate with your calendar, we're probably looking at late August anyway. Therefore, we'd be able to informally do discovery or even formally if necessary. So that's kind of my thought on the situation, Your Honor.
Yeah, Mr. Ruiz, you're right. It's probably looking into late August for, I'm guessing the parties wanted a full day then for a final hearing. I know there's been a divorce and the property settlement agreement, and so just the child custody and child support remain, but sounds like maybe a full day for that. And so we are probably looking late August. So if the parties want to continue informal discovery, I don't have an issue with that. If you need a more formal deadline or order, we can certainly do that too. But it seems like that would be, I would agree, Mr. Ruiz, that's probably the best use of time, is just get it set for a final hearing, hopefully sometime in August.
I would agree, and I think Tony and I can work together to. I don't think any discovery would be too difficult or too in depth. Really, just being the custody and custody issues and child support are the only ones remaining. We don't have the property issues, which are typically the bulk of the discovery, I suppose, in a divorce.
I think that's accurate, Your Honor.
Okay. Do we need and the parties can remain on? I would ask Mr. Ruiz, would you be able to do a journal entry from today's hearing?
I will, Your Honor, and I'll reflect the denial of the hair follicle, and I'll put in the final hearing date also, Your Honor, if that will accurately reflect everything you want in it.
Perfect.
Hey, you might just put that the hearing on Wednesday is removed from the docket or calendar.
And then do the parties want just a short pretrial, 30 minutes before the final hearing? It may be good at least for a deadline to exchange exhibits, that type of thing.
I don't
But
think
we can do, and we could do that by Zoom, so Mr. Ruiz doesn't have to travel up here and spend additional time driving. So if that sounds good to council, then anything further from either party?
Nothing from Petitioner, Your Honor.
No, Your Honor.
Okay. Then we'll be adjourned. If the parties want to remain on the Zoom, Ms. Scheck will get those dates for the final hearing and for a pretrial, and then we'll go from there.
Thank you, Your Honor.